27th, and others to be entitled an act to amend Article 9 of Chapter 12 of Title 16 of the Official Code of Georgia Annotated relating to access to medical cannabis, so as to authorize the governor to issue initial Class 1 and Class 2 production licenses for limited period of time. This bill having referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Werkheiser to present the bill.
Thank you, Mr. Speaker. In my 8 years of presenting bills, I have never spent more than 60 seconds in the well. That changes today. First, I've got to thank some folks, and the first one's not even here, and I'm sure he's watching unless he's at a high-dollar golf tournament, and that's Alan Peak, who started this process years ago. But after that, when he left, Michael Gravely said he would take up the mantle and move this process forward. And this year we saw a couple other people put a lot of effort into this, and that's Chairman Powell and Chair Lady Sharon Cooper. And as we were going through this process trying to figure out what to do, the Speaker, as he often does on the big measures, got us all together. And I'm going to just pause here for a second and talk about something that, you know, corporations spend tens of thousands of dollars coming up with a logo or some kind of cute phrase to fit their organization, then they try to meet that. The opposite happened in this House once this Speaker took charge, and that is the House leads. And I can just name you a few in the past few years. You know, when it came to adoption change, the House led. When it came to rape kit, elimination of the backlogs, the House led. When it came to mental health parity this year, the House led. And now it's our time to lead on medical marijuana. I wish I could say we're in a good spot, but we're not. We've had patients now numbering 20,000. We've got 20,000 families waiting for us to do something. If we do nothing, we're in a bad position. If we do something, it's not so great either. But I think we've got something that will move the process forward, and so I'm going to run through that. And again, I want to thank Gravely, Powell, Cooper, and the Speaker's office for this collaborative office, because this is not my bill. This is all of theirs. This legislation is aimed at resetting the medical marijuana license process to improve transparency and the professionalism of these operations. This issue is too important to get it wrong, and so this is what we're going to do. We're going to direct the Commission to immediately cancel the current RFP. That means there are no protests, there are no licenses. I guess we've literally created a time machine. We're going back about a year and a half. We're going to direct the Commission to immediately take steps to procure or obtain, no later than August 1st of this year, low THC oil in amounts necessary to meet the needs of the patients in this registry. This will kickstart the program and get it going while we fix these other things. It'll direct the Commission to immediately take steps to provide for dispensing low THC oil to patients no later than August 15th. It will direct the Commission to issue a new RFP after the above items are complete, but no later than December 31st of this year. It will require the RFP to be done a little bit differently. First of all, it's going to be managed by DOAS, because this is something that they're used to doing. And then the scoring is going to be evaluated by a third party, independent third party. And then we're going to provide that the RFP be subject to state purchasing laws and open record laws, which still protects trade secrets and IP, intellectual property. As the previous RFP, it's going to provide for two Class 1 licenses and 4 Class 2 licenses. But so that we don't have to keep addressing this as the medical cards keeps growing, we're going to go ahead and say that as the registry increases by every 50,000 patients, we're going to allow an additional Class 1 license, an additional Class 2 license. There's going to be transparency throughout the process. It's going to require monthly updates to the Medical Cannabis Commission Oversight Committee. And then we're going to revise, since we're now behind schedule, revise dates for minority and women participation in the program. It's going to provide increased immunity for the Commission and the designated universities for the transport. And then a year or so ago, Representative Walensky added ulcerative colitis to eligible conditions. The House passed that. The Senate removed it. We're going to put it back in. It reduces the distance from 3,000 to 2,000 feet for a license to be operational from a school, church, or synagogue, and then additional legislative findings. Mr. Speaker, that's the bill, and I'll stand for any questions.
Do you yield for questions?
Yes, sir.
Chair recognizes the minority leader, Leader Beverly, to your left for a question.
Does gentleman yield?
Absolutely.
I just have a point of clarification. During the interim before the Class 1 and Class 2 licenses go out for RFP, there's an interim quantity of medical marijuana that needs to be produced. Is that going to be sole sourced, or is it going to be someone who's already bid on that to provide the minimum amount of medical marijuana for the patients who need it?
I mean, for the oil that the commission's going to be allowed to get,
yes.
It will not be sourced from any of the current licensee holders, since there are none. So they'll have to procure them from either other sources or governments.
Okay, thank you.
Thank you.
Do you further yield?
Yes, sir.
Chair recognizes the Dean of this House, Dean Smyrie, to your left for a question.
Gentleman Yell.
Yes, sir.
Let me ask you something. In terms of the licensures that are existing now, will they have to reapply, but they won't will they have to pay again? I mean, explain that process.
Yeah, that's a great question. Appreciate you bringing that up. And unfortunately, we've got a couple of licensee holders that have not been signed that have invested a lot of money. So they will, in fact, be treated like everyone else and have to reapply. But in the bill, we have exempted them from paying any fees because there is a hefty application fee. So anybody who's already paid that fee will be exempt from paying that fee. But to the first part of your question, so yes, they will have to reapply like everyone else.
Gentleman, further yield.
Absolutely.
In the Class 1 and the Class 2, the way we had it the last time, you know, delineate this time. You said that was 12.
No, it's still 2 Class 1 and 4 Class 2.
Okay, so the number will stay the same.
That is correct.
Okay, I misunderstood. I thought that we were changing the number and upping it, the eligibility or the requirements for the license, but the license was
not until we add until the medical card holders reach 50,000 will we not add to that again.
And then one last question.
Yeah.
Under the auspices of the university system, UGA and Fort Valley State, they will authorize a licensure under the statute as well. They will continue to proceed in terms of their application. They won't have to reapply.
That is correct.
Thank you.
Do you further yield?
Yes, sir.
Chair recognizes Representative Gilliard to your left for a question.
Will the gentleman yield?
Yes.
Thank you for this bill. You mentioned about minority and women participation. Can you further elaborate on that?
Yeah, in the previous RFP, we had stipulations for that, and that will continue in the new RFP. So what we did, after there's been some period of seeing how they've operated, and I understand the licensees that were supposedly awarded, they had that already in there, and their scores were elevated for having that. But what this study will do, it's going to look back and see, and if there is not adequate minority or women participation, we will grant a license in addition without reaching the 50,000 threshold so that we do meet those qualifications.
Does the gentleman further yield?
Yes.
Which department would this actually go through? Would it be agriculture?
DOAS.
Okay. Would the gentleman further yield for
Yes.
one more question? When we did House Bill 213, the hemp industry, there was probably a concern about minority participation. And so I thank you for this bill. It's a good bill, and just encourage that we further follow up on holding that to be true.
Thank you.
Thank you.
You further yield?
I'll take one more because I know there's some other speakers who want to speak to this.
Chair recognizes Representative Dukes to your left for a question.
Would the gentleman yield, please?
Yes.
Is it not true that we are continuing the same process, except rather than it being handled by the commission, that it is now being handled by DOAS?
Well, the commission is still involved, but the scoring and application after the commission releases the RFP, that's when DOAS and a third-party scorer steps in, but the commission is still in place.
Would the gentleman further yield?
Yes.
Inasmuch as it was as much confusion around the mechanism of selection, was any thought given to a different process?
Well, there's been thoughts about every phase of this, but I'll tell you this, I know the commission's taken a lot of hits. That commission is made up of some very intellectual, very successful people. Part of that process, that ownership goes on the legislature for not having the guardrails in place, and I think we've done that in this bill. Mr.
Thank you.
Speaker, at this point, I'm going to yield the well and let those others speak to this bill. Thank you.
Okay, we have other members that wish to speak to the bill. Chair recognizes Chairman Setzler to speak to the bill.
Ladies and gentlemen of the House, I rise today. I'd like to start by thanking the Speaker. The Speaker's dialed back in a process that I think was spiraling out of control. I think the proposal that had been brought that would have expanded the number of producers to more than 20 was kind of a runaway train, and I appreciate what the Speaker's done to dial this back. It's limited to the number of providers that was initially proposed, and I think I just want to make that statement here that what we have before us is better than what had been proposed. I'd like to thank the Speaker for that. Having said that, I want us to understand what we're doing here, and what we're doing is, in this bill, moving a step forward in a process that I think is dramatically different than what this body acted on 7 years ago when we passed the Haley's Hope Act in 2015 that was going to provide small quantities of low THC oil to address kids with acute medical conditions and focus on their conditions specifically. I think many of us came together then and passed a bill that we can feel good about. Because small quantities of low THC oil for acute conditions is something I think we can all be very proud of. But let me say without any uncertainty in my mind, and I think I want to make this clear for Georgians, and I want to make this clear for this body, what is before us today, we're a part of it. This is a process. The fact that we're in the face of a protest where 22 providers came in to provide oil-based THC to Georgians. The fight here is one of making money on producing this. Now, I'm a supporter of the free enterprise system, and I believe with the free enterprise delivery system is an efficient, appropriate way to deliver services. But make no mistake about it, friends. What we have before us, not specifically in this bill, but in this movement towards expansion of legalize marijuana and THC in the state is something we need to be very cautious about. Again, I appreciate the constraints that leadership's put on this bill before us. I think it's a better bill than what was being proposed. But I want to say to Georgians, and I want to say to this body, we need to be very, very careful. The monetization of THC, whether it's an oil-based form or the expectation in the future of it being a smoked form, is what's happening behind the scenes and what's happening below the radar screen. I want to caution us, this body, if we're going to be wise, needs to continue to put constraints on the use of low THC oil so it can be used for specifically medicinal purposes at low concentrations for specifically acute conditions. I'll close by saying a couple years ago in the Judiciary Non-Civil Committee, we had a bill that came through purported as a low THC bill that would have allowed for, again, it was called a low THC oil bill, but it would have allowed for up to 20 ounces of 60 to 80% pure THC honey oil to be used at a street value of more than $30,000 in that quantity. That's what that could be bought for for its street value. That was what was being proposed to our Judiciary Committee as low THC oil. Friends, there is a movement behind the scenes, and it's very soon going to be out in the open, that's going to be monetizing this process to push for full-on what you would call medical/recreational marijuana and making Georgia a recreational state. That's coming. The money behind this that's protesting these RFPs is driving this. It's a nationwide movement, and it is coming to Georgia, and they see this process as just a step in that direction, to build the infrastructure, to build the providers, to expand the providers so that we can have full-on what they originally called medical marijuana, which was any doctor who believes in the legalization of marijuana can write a script to let folks have marijuana, and then behind that full-on legalization. So friends, let's not be fooled by this. I think the Speaker and the leadership has done a great job of constraining the bill that's before us, and I commend the House for that. But make no mistake about it, we are taking steps towards setting up the financial infrastructure to create a lobby and a financial set of interests that will drive through recreational marijuana in this state, and for that we all need to be very, very, very concerned and vote cautiously as we vote on this proposition today. Thank you.
Chair recognizes Chairman Alan Powell to speak to the bill.
Thank you, Mr. Speaker, and the ladies and gentlemen of the House. After I listened to that last speech, I'm not sure if he was for it or against it. Yeah. But I will certainly tell you the same thing I've always said, and said it back prior to the legislation 3 years ago, that anything that the good Lord lets grow natural's got to be better for something made better than some drug made in some factory, folks. Now, where are we at today? I thought Chairman Werkheiser did a pretty good job explaining the bill, and I'll get into some other parts of how this came to be. But I want to talk about what this is really about. And it's really about those children and those sick individuals. Y'all remember, all of y'all who were here 3 years ago, do y'all remember the balconies being full of children that suffered from seizures, from illnesses? This is what this legislation is about. And why is it here today? It's here today because the absolute worst, the absolute most terrible part of government bureaucracy is what transpired over the last 3 years. The Cannabis Commission was established. The governor made his appointments, and Speaker made his, and the late governor made his, and I'm not sure what happened in between, but to the best of my knowledge, it was absolutely disgraceful. Disgraceful to the people of this state. When we got started into this issue back in November, your Regulated Industry Committee had hearings during the reapportionment, and we just casually asked the director of the Cannabis Commission to come over and testify so we might could get a little information about what was taking so long. Let me tell you something. If you've never been insulted, You need to sit in the chairman's position and assemble your committee and ask a state bureaucrat questions. That was the worst I've ever seen. You ask him, what was their process? I can't tell you. We aren't allowed to talk about it because it was hidden and embedded in the legislation that said we can't discuss nor disclose, or there was no open sunshine into the process. We asked a number of questions. Finally, I gave up and I said, well, can you ask one question? Can you tell me if y'all used any third-party consultants? Can't answer that question. What color's the sky? I can't answer the question, folks. And this is where they were. And that prompted a level of investigation and that came on behalf of the committee. A lot of y'all that know me, I'm not very much about asking questions and not getting answers. Yes, me, Al. But also, this represented an insult to this house, the people's house. That we were the front runner on this issue about medical cannabis oil to help these sick people in our state. We started work on the committee, and we looked into it, and we started realizing what a complicated situation because of the legal community. Under the terms of the law of 3 years ago, it said that there would be 6 licensees, 2 Class 1, 100,000 square foot, 4 Class 2, 50,000. And we're not talking about chump change that was involved in it. We're talking about $100,000 license applications for one and $50,000 for the other. We're talking about the consultants out there who put together these intricate sets of blueprints and plans that would be submitted per the instructions of the Cannabis Commission, whether it was about minority participation or about the security or about the financial well-being or about where they were going to be located, and you name it, and it was there. Again, best I can tell you, an insult to the people of this state. They've dragged on for 3 years. So when we started looking at it, we found out that the Cannabis Commission had gone through some kind of a process to evaluate the applications. There were 69 applications. And they went through this application process, and as God is my witness, I don't think I've ever seen anything as terrible as what we found out. And how we found out wasn't from the commission, and it wasn't from the people, the 6 that were tentatively approved. It was from the 16 plus that either filed a protest or the others who just walked away because they threw their hands up at it. Folks, we don't do business like that in the state of Georgia. We don't. But this process, if you can imagine this, they divvied up the contracts and the requirements into sections. And they gave each one of the 6 commissioners a little section, and they said, you judge this and put a numerical value on it. They didn't look at the rest of it, and then they tossed it in a pie and they added it up. I smell a rat in the woodpile, folks, because something told me that this thing was destined for hand-picked folks. But that's how it was. So you had 6 companies, 6 of the companies that had been tentatively approved. You had 16 of the companies that in the original legislation, they had grounds to file a protest. And we had 16 that filed a protest, and pending legislation, since they were the only ones that we were told that would have legal standing, that these 16s would be filing legal litigation based on the failure of due process of the application evaluation process. Now, I'm not a lawyer, but that sounds pretty rich to me, folks, you know. Sounded pretty fair because I didn't just get that from the attorneys representing the protesters. I got this, the committee got this information from litigant attorneys that had nothing to do with it. They said that yes, it would. And we realized at that point that what we were looking at was that process, if once litigation was filed, it'd be filed in Fulton County, It would come up at some point down the road, go through the Court of Appeal. So we were told that we could be looking at 3.5, 4, 5, 6 years to be embroiled in litigation. The same as a lot of other states that went through this, strange enough. So we came up with an idea, well, let's short circuit the idea. Let's just give the protesters licenses. That's the only way that we knew to do it, because the 6 that had been tentatively chosen, we didn't want to get into their rights so that we give them reason for litigation. So, you know, we did a lot of things. We opened it up. We did away with the secrecy clause. We opened it up so the sunshine could peek in, so that them folks back there in that glassed-in room and them folks you see on TV that's been reporting all of this, that they could get involved and start asking questions to ferret out what was really going on. This is the direction that we went on 1400. My colleague, Ms. Cooper, put in a bill that had somewhat of a different approach to it. Her approach was to let the Medical Association of Georgia have control of compliance and the list and all of that of the actual folks who were filing to get the medical cards. And hers even went as far as to add 6 more. Something I disagreed with, but you know, you had 3 different chairmen in this House. We all had a different approach. Chairman Workhauser, he put in one that said the governor could pick one or ever how many number of the 6 to go ahead and get it started, because this has been dragging on way too long. So then you had the wisdom of the Speaker's office. They called it in. They looked at it. They are the attorneys. I'm not an attorney. I actually work for, I'm sorry. I'm not an attorney. I rely on attorneys. But the Speaker's office drafted this document in front of you. And what this document does, as I was so aptly told by one of my friends in there, this ain't gonna make anybody happy. Well, it hadn't. But it's almost humorous to me that the folks out there that had been petitioning, that they were pretty full of themselves because they were tentatively approved. They didn't even want to talk to us. By gosh, they wanted to talk now. But this document that you see in front of you that was crafted as a substitute that came out of the Speaker's office, it does away with the RFP. It starts back to scratch. Now, as I said, I'm not a lawyer, and I don't know if this is going to produce litigation or not. But I know that this is probably the fairest thing to do. It would be the fairest thing to do, because those six, they're going to have to reapply. The 16 that filed a protest, they're going to have a chance to be reevaluated. The other 40-something are going to be reevaluated. And then somewhere out there, maybe that guy that, maybe the folks that played the ukulele in the committee for us, they might even put in an application, the people from wherever they're from. Because this opens the process back up. But most important, ladies and gentlemen, what it does, it moves this process out from a bunch of appointed folks, and it moves it into the hands of the professionals at the Department of Administrative Services. And they will hire third-party consultants to evaluate any and all, and they've got a time limit to get on moving. They'll have to issue a new RFP before the end of the year. That, ladies and gentlemen, is what this does. I applaud the Speaker's office. I had a lot of y'all out there that asked me what my thoughts was. I said, by all means, vote for this. Let's get it on across. You know, we've got a little bit of time, because we're going to have to deal with that crowd across the hall, and if they can file up something, they're going to do their best to do it. So maybe if we get it on over there, we can get moving. So ladies and gentlemen, I would ask for your support for this substitute, and let's move on, and let's see if we can get this system repaired and in order for the people that are deserving it. Mr. Speaker, I'll yield the well.
Chair recognizes Representative Gravely to speak to the bill.
Tough act to follow. Thank you, Mr. Speaker. I want to very quickly talk about, we've talked a lot about bureaucracy. We've talked a lot about fines and fees and applications up here, and I want to take you back to a moment in 2014 where those of you who sat in this house and this issue was being debated from this floor by then Representative Alan Peake, many of you really had a battle over whether or not this was appropriate. This was a controversial issue. This was an issue that we had multiple caucus meetings over. The hallways were filled, news articles were being ran on a measure that Georgia had passed in 1979. First time. We were one of the original states. And it didn't start in 2013 and 14. It started in 1979 and 1980. And it was started by a woman by the name of Mona Taft, who was advocating on her husband, or for her husband, because he had cancer. And she found out that he had gotten relief from this. So she came up here. His name was Harris Taft. And, the irony is that we sat and worried about this issue in 2014. But let me tell you what happens in just 10 short years. We have not become a recreational state. We have not implemented medical smoking or anything like that. Matter of fact, we have a very strict law. You can't even advertise with the color green in our law. There are no edibles in our law. You can't even have a standalone education center in our laws. For anyone that would want a patient seeking this who has been recommended by their physician, who's wanting education on this particular subject, you can't even have a standalone education center. Ladies and gentlemen, in 2014, we struggled. And this was a brave and courageous vote by a lot of you. But today, we stand here in this same chamber, everyone in agreement. How do we get this to the children? How do we get this to my constituents? Because over the last 10 years, we have realized that there are constituents in just about every one of your districts that needs this. Yes, it did start out with some children and their parents that came to the balcony, they came to the rotunda. But friends, I'm going to tell you, this affects young and old. Look at the diagnosis that we have in our law. Children don't get Parkinson's disease. How many people suffer from MS, Tourette's, sickle cell anemia, ulcerative colitis? There's a lot of people in this state that will benefit. So I want to make sure that we understand this process does not change the minority aspect. The inclusion of minority companies does not change that. Matter of fact, it puts an onus on Fort Valley State to go ahead and get moving. It puts the onus to let's get this moving forward now. Now, the previous speakers were correct. The voting or the application process was tainted. Should they have hired a third party? Yes. Should that have been taken care of already? Yes. This time it will be. And those 69 companies that went through the application process will not be charged again. They will go through, they will be voted, and it will be a clean voting process. It will be a clean grading process. But folks, I want to leave you with this. 20,000 peer-reviewed medical journals have been written on the efficacy of this substance. 20,000. Our Medical Association of Georgia has created its own internal review committee because the doctors in the Medical Association realized that more and more and more of their patients were finding relief, were finding positive effects from this. And the doctors wanted to know more. They want to be able to have that ability to sit down with their patient and discuss this openly and freely. Friends, I'll tell you, last night we had a town hall meeting. Myself, Representative Momtahan, Representative Gullett. We were very blessed to have Representative Irwin, our chairwoman, Rich, come out to us. And at the end of that, a gentleman running for county commission in my district, 47 years old, stopped me at the end of that. It was a totally different subject that the town hall meeting was being presented on. And he said, I want to thank you for your work on this, because in 2005, I was diagnosed with leukemia. And I went out to Colorado, and I would stay for 5 days, and it wasn't confirmed in anything. It was just an opportunity that a doctor had told me about. He said, but today I'm alive and well. And I attribute that to those treatments that I took with medical cannabis in Colorado in 2005 and 6, long before we were discussing it in present day here in our state. Ladies and gentlemen, there are families in this state that needed this 10 years ago, 15 years ago. And now all of us are trying to figure out a way to move it forward. I thank the speaker, and I want to credit the speaker with this. From day one, the speaker has been with us. From day one, the speaker has helped lead the charge. From day one, he has set, and just like everybody else that was involved in this issue in the beginning, he has racked his mind, his brain, in trying to figure out a solution. Mr. Speaker, I thank you for that. So this bill moves it forward in a clean process to be able to get this. It's got dates that are implemented. It looks at the open records problems that the previous bill apparently had, although I do not believe that was the legislative intent. It apparently had some. I would ask for your favorable consideration on this measure so that we can do something in this state 10 years later to get these folks the medicine that they need. Mr. Speaker, thank you. I yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Chairman Houston rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, isn't it not true that my heart goes out to these children and I'm for the bill, but after I voted for the last bill, isn't it not true that on lines 24 regarding legislators can own 5% of this, no more than 5%? I didn't realize that was in the bill before. And is it not true? Would somebody explain that to me?
Well, the fellow sitting to your right there might take a shot at it.
I wave.
He waves.
And I'm not going to give you a high five on that one. Isn't it not true that I think that this is some way a great opportunity that we can get this cleared up, that legislators, this is big business that we're voting on, and legislators should not have 5% of it. Thank you.
Chair recognizes Chairman Carpenter. Or what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true there's a lot of talk about how tight the language is on this bill, but it does not, it pales in comparison to how tight the supply of this oil is for the consumers of Georgia?
I would agree with that. What purpose does Dean Smyrie rise? He waves. What purpose does Representative McLeod rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that I was born in the island of Jamaica?
If the lady so states.
And as such, we have been accustomed to making sure that medical marijuana has always been in good use.
I'll take the lady's word for it. What purpose does Representative Erica Thomas rise?
Is it not true that I don't want
What
to go
purpose do you rise?
parliamentary
State
inquiry?
your inquiry.
Is it not true that I don't want to go after Representative McLeod's statement? But I do have a question. My parliamentary inquiry is just to ask a question and make a comment, and that is saying that in this bill, it would be getting rid of the last 6 licenses and giving out 6 new licenses that would make a independent consultant to be able to make the decision to the board whether or not they believe that the 6 new licenses should be given out.
Well, I think they'd be making a recommendation based on some established criteria.
Further inquiry?
State your inquiry.
Is it not also true that with lines 76 through 81, it does state, which is my question in the committee was, it does state that this would still be able to have the 6 licenses would have the privacy and the exemptions that they were able to keep before?
Well, no, there are not 6 licenses now. The licenses have not been issued other than to the Fort Valley State as the license. That's the only license that's been issued. The 6 that were the successful bidders have not been awarded a license.
Thank you.
What purpose, we're just going to do 1 or 2 more of these and then we're going to lock it down. What purpose does Chairman Setzler rise?
Parliamentary inquiry, Mr.
State
Speaker.
your inquiry.
Isn't it true that if there's skeptics in this whole process, this bill actually puts more integrity in the process and brings this whole process back to where the original intent of the legislature was, which is a limited circumstance to provide low THC oil?
Well, that was certainly the intent.
Thank you,
So, what purpose does Representative Gravely rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that had the commission been able to hire a third-party consultant at the original application process, that we would not have had to go through the extent of protests that we did currently, or that we are going through currently?
The chair feels like the gentleman is accurate in that statement.
Further inquiry, please.
State your inquiry.
That these consulting firms that DOAS would work with have graded other applications in other states, that they are attuned with what these companies need to do from a security standpoint, a harvesting standpoint, that these companies' sole purpose are to grade applications in this manner across other states to make sure that these states are getting good companies to make medicine.
That's my understanding. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 1425, the ayes are 169, the nays are 5. This bill, having received the requisite constitutional majority, is therefore passed.